Public Service Commission is an independent commission established under Article 233 of the Constitution of Kenya.
The Public Service Commission is the oldest of the commissions and independent offices listed in Chapter 15 of the Constitution, and its mandate is very, very well articulated in Article 233 of the Constitution. The mandate of the Commission includes the provision of competent human resource, promotion of good governance, and ensuring that there is efficiency and effectiveness in the provision of quality services to Kenyans' citizens.
The Commission has a vital constitution and statutory mandate of ensuring merit and fairness in the discharge and management of human resource functions in the public service. The mandate sets the impetus towards achieving a citizen-focused and ethical public service.
Section 86 of the Public Service Commission Act 2017 provides that any person who is dissatisfied or affected by a county public service decision can appeal to the Commission. And matters appealable to the Commission include decisions in respect of recruitment, selection, appointment, promotion, designation, deployment, and qualifications attached to any office. Further, the remuneration and terms and conditions of service. Also included is disciplinary control, including dismissal or imposition of any other punishment. We also deal with the national values and principles of governance and the values and principles of public service as provided for in the Constitution. So we try to cascade this down to the county governments. Other matters that we deal with include retirement or other forms of removal from service, pension benefits, gratuity, and other terminal benefits. We also look at any other decisions that the Commission considers to fall within its jurisdiction as provided for by the Constitution. Whereas the Constitution in Article 48 guarantees the right of access to justice, the rights of persons affected by decisions of a county public service is dependent on the exhaustion of the appeal process to the Commission. This therefore calls for expeditious disposal of appeals filed at the Commission in accordance with the provisions of Article 47 of the Constitution, which expects that the Commission shall handle appeals expeditiously, efficiently, lawfully, and in a procedurally fair manner.
Disciplinary control in the public service is one of the Public Service Commission's functions as stipulated under 234(2)(b) of the Constitution. Public officers are expected to maintain integrity and uphold the dignity of the office to which they are appointed. It is therefore imperative that every public office adheres to the rules of conduct and ethics as laid out in the law. Indeed, while exercising the powers of disciplinary control, the Commission is alert to the fundamental principles of natural justice.
The Commission is a respecter of the rule of law and strictly adheres to what is provided in law when dealing with disciplinary issues. The principles include the following: the rules of natural justice, which include procedural fairness, where an officer must be allowed adequate opportunity to prepare and present his or her case. And that's why in our discipline manual, we provide for the timelines to which officers and the authorized officers must take into consideration when handling a disciplinary case. And that is what we call natural justice. Give me time to respond to the charges. Impartiality of the deciding authority when hearing and making decisions. That is again a principle that we must be impartial. Decisions which are based on logical proof or evidential materials. You see, we need to have evidence so that we are not just treating people in a way that they can regard as being unfair. So that what we were saying earlier, an investigation must be conducted where evidence is allowed. That's why we say, please, as much as possible in a disciplinary case, document, document, and document. The other principle relates to fair administrative action, which is expeditious, efficient, lawful, reasonable, and procedurally fair. This is provided for under the Fair Administrative Action Act, and the Public Service Commission has undertaken within its guidelines to institute fair administrative action where an officer is being disciplined, and therefore every person to whom disciplinary action is taken has the right, for example, and this is fair administrative action, written reasons for any disciplinary action that is undertaken. Why am I being disciplined? Why is it a gross misconduct? Number 2, prior and adequate notice of nature and reasons for the intended disciplinary action. So you must be told what is the nature of offense and why am I being disciplined for this offense. Number 3, an opportunity to be heard and make representation. And normally, the persons will be allowed to even come with their representatives during a hearing. You can come with your lawyer, you can come with your trade union representative, you can come with your friend. So this is within the disciplinary process. Number 4, an opportunity to attend proceedings in person or in the company of an expert of choice, cross-examine persons who give adverse evidence and request for adjournment of proceedings where necessary. So that if I am undergoing a disciplinary process and I feel unwell, I can request for an adjournment of the proceedings and it should be allowed. Where I have brought a representative, he should be given a chance to prosecute my case before the disciplinary hearing committee. 5, legal representation where affected officers so requests. So an officer can be allowed to come with their legal representative. Notice of a right to an appeal review against the disciplinary action. I have already mentioned this. Number 7, information, materials, and evidence to be relied upon in making a decision or taking a disciplinary action. These are what we call the fair administrative actions that you must take into consideration whenever you are undertaking a disciplinary process. And the Commission shall look at the case as submitted to the board or to the Commission and see if indeed there was fair administrative action or not.
Alternative interventions are an effort undertaken by an employee to address employee misconduct using a method other than the traditional disciplinary action. These interventions include counseling, guidance and training, establishing dispute resolution mechanisms. When applying alternative interventions, the following should be observed: the specific offense, shortcomings that need to be addressed, officers' admissions of wrongdoing, willingness to, the specific form of alternative intervention that will be used and its duration, notification of the possible penalties for a subsequent offense.
Discipline is not always about dismissing a person. This person, in terms of good human resource practice, must be listened to, and we need to understand people, the softer skills in HR, which allow us to probably counsel a person to go back to doing their work in the manner that is expected, probably because of they are undergoing either behavioral or social issues that are extraneous to the workplace.
Public Service has delegated the following disciplinary powers to authorize officers as per the Public Service Commission regulations and instructions issued to the service from time to time. 1. Interdict any of the officers. 2. Suspend any public officer. 3. Inflict a severe reprimand or reprimand on any officer. 4. Stop any public officer's pay salary. Recovery of the cost or part of the cost of any loss or of breakage caused by default or negligence. Withholding, deferment, and stoppage of salary increment. Reduction in rank or seniority in respect of officers in Group Job P and below, with the exception of all officers who have qualified for pension. Dismissal in respect of officers in Job Groups P and below, the exemption of all officers who have qualified for pension.
According to the guidelines, Disciplinary cases under delegated powers should be processed through the respective human resource management advisory committees. What we are saying here is that disciplinary powers are of two kinds. There is that is exercised directly by the Commission and that under delegated powers. And the Commission has set out the delegation in instruments of delegation to authorized officers.
A person who is dissatisfied with the decision made in exercise of delegated powers has a right of appeal of the Commission through the authorized office within the period of 42.
The County Government Public Service Appeals Procedures and Regulations 2016 provide a clear procedure to be followed when lodging and processing county appeals. The regulations generally require the Commission to receive, hear, and determine an appeal within 4 months of receiving the appeal. The appeal procedure entails the following steps. Step number 1 is receipt of the appeal at the Commission. Step number 2, upon receipt of the appeal, the Commission notifies the relevant county government public service institution of the appeal within 7 days of the lodging of that appeal. The county government public service institution is required to submit all records in relation to the appeal, including proceedings that led to the decision being appealed against within 14 days of receiving the notice. The committee will hold a preliminary meeting to review the appeal file within 21 days of the reply being filed. Where there is insufficient information to make a determination in relation to an appeal, the Commission may investigate the matter further in order to obtain the required information necessary to make a determination. The Commission's Committee on County Appeals convenes a final meeting within 21 days of preliminary meeting or within 14 days of obtaining findings under Regulation 1116 to consider all the information and documents in relation to the appeal and make a final determination in accordance with Regulation 11, subsection 10. The Appeals Committee deliberates and makes its findings and recommendations to the Commission within 14 days of the final hearing or the final written submissions made in relation to an appeal as provided in Regulation 16. The Commission then considers the recommendation of the committee and makes a final decision on the appeal within 14 days of receiving the recommendations of the County Appeals Committee under Regulation 17. The decision of the Commission is then communicated to the appellant and the respondent in writing within 7 days from the date the Commission makes the decision, as guided by Regulation 19.
Indeed, the Commission expects that the various developed policies and institutional changes, more so on appeals and reviews, will re-engineer and transform the respective intergovernment relations to be more professional and productive, leading to provision of quality services to the people of Kenya.